I'm Craig DeRoche, CEO of Family Policy Alliance. Today, we're diving into an issue that goes to the heart of religious freedom in America's schools. In 2018, John Klug, a teacher at Brownsburg Community Schools in Indiana, resigned after his request for a religious exemption from the district's pronoun policy was revoked. He asked for his civil rights to be upheld, and he was denied. Klug had sought a simple accommodation addressing all students by their last names instead of using preferred names and pronouns, but the school reversed its approval, ending his career. You thought you couldn't get rid of a teacher in America? You can, apparently, if they use the wrong pronouns, and asserted to their religious liberty. Since then, his case has wound through the courts, though. John's case is headed to a jury, and what happens there could set the tone for how schools nationwide handle religious liberty in the classroom. Josh Hershberger, the director of the Church Ambassador Network, and he's the general counsel, a brilliant lawyer as well for the Indiana Family Institute, has been involved in this case from the beginning, and he joins us to discuss the importance of it nationwide. Josh is from Hanover, Indiana, where he lives with his wife and children, and he serves in church leadership along with his legal work. I'm so excited to have you with us, Josh. What is going on with this nonsense of a school teacher that is, you start with your explanation of this.
Well, just to affirm what you're saying, Craig, this is so basic. We have the First Amendment. No teacher should be forced to choose between their conscience and their career. This is a reasonable accommodation, treating all students the same, simply using a last name. And it cost, as you said, Mr. Klug his teaching career, something he deeply valued and perceived as a calling and a ministry for him. So to go back into the facts a bit, this case actually starts in 2017. Now, that year is important because if listeners will think back, this is 3 years before the Bostock case, where the Supreme Court weighed in and said that sex in the employment context means sexual orientation and gender identity. Wrongly decided, we believe. But just thinking back to 2017, this is completely new. There's no case saying this is the law. There is certainly no state statute saying this is the law. And here's Mr. Klug, who I can say, having spent some time with him, is just a delightful Christian. He's a humble man. He is kind of the perfect individual here. He's not an influencer. He's not looking to start a case. I'm sure he never dreamed of being the center of this type of controversy. And the school comes to him in 2017 and says, you have to refer to transgender identifying students in a manner inconsistent with the biological sex. So basically a boy claims to be a girl. Well, you've got to refer to this student using those feminine pronouns. He, in good conscience, says, I believe that God created us as male and female. I can't do that, but I want to live peaceably. I want to be respectful in the classroom. I don't want to cause division or issues if I don't have to. So, the most basic accommodation request, can I use their last names just like a coach? And the school said, fine, you can do that. And that accommodation request was in effect for an entire year, and it worked great before the school revoked it and then gave him the choice of either being fired or resigning to keep his summer pay. And so that's the long and short of what happened. We can dive into more details, but here you have a strong Christian trying to do the best job he can as an orchestra teacher, referring to all students by their last name, and he loses his job over it.
And this is one of the most amazing things about this, folks. And Josh and I are going to talk about some analogies here. This is just as backward, 180-degree backward as you would think it is with human basic communications 101. But I want to start with, these are lawyers. Josh is a brilliant lawyer, but these are people that went to college. They have a terminal degree in the law. They read the books, is what I'm saying. And they're saying, in representing their client, the school district, that using last names caused, quote, this is their words, emotional distress for students. The court recently said the school failed to prove that claim. How important is that finding, that this idea that pronouns create emotional distress? What's going on with that?
Sure. And so you mentioned lawyers, and I did want to give a shout out to 3 attorneys here in Indiana who took up this case initially. And then as general counsel for Indiana Family Institute, we've submitted an amicus brief. But Michael Court, Kevin Green, Roscoe Stovall, again, diving into a case of essentially first impression. And they're willing to jump in despite all of the, the cultural pushback. And they initially litigated this case, and then Alliance Defending Freedom jumped in later. But as you mentioned, the school has said, well, actually, this causes an undue hardship to the school. That's the standard for religious accommodation. The school must grant the religious accommodation unless it causes an undue hardship. So what happened in that 2017 school year, even though the orchestra department, and this is in the record, was successful, other students didn't perceive any problems, there was a leader of a student group called the Equity Alliance Club. This is an LGBTQ group that sends an email complaining that two students, and Lee, the leader of this club, characterizes it as emotional distress. Now, this individual is not a licensed professional. He is a group leader, and we have two students that say they felt like they were being mistreated. Another anonymous student, two teachers, or two complaints from a parent, and then two teachers that spoke up. That's it. There's just a few grumblings among those in the school that they didn't like this policy, and just subjectively said this caused emotional distress. And the district court bit into that, and they used that as the reason. It's a valid reason for denying this religious accommodation and Klug losing his job. Now, I don't want to get too in the weeds here, but just understand this case started in 2017. Last time I checked, it's 2025. So I think this is important to know. So the district court rules against John, against the teacher, against Klug. It goes up to the Seventh Circuit, and the Seventh Circuit basically affirms that decision. Klug says, wait, this can't be the case. Asks for the entire Seventh Circuit to review the case. And while that's pending, the U.S. Supreme Court made a very important decision. And I'm sure listeners are familiar with what's called Groff versus DeJoy. And essentially this case said, look, in religious accommodation law, an undue hardship isn't just a slight inconvenience. And I'm paraphrasing a bit, but it has to be more than a slight inconvenience. It actually has to be, an undue hardship. And so Seventh Circuit said, hey, district court, you need to reevaluate this case in light of the Supreme Court changing the standard. The district court, and again, I'm simplifying here, but essentially copies and pastes its former decision and still rules against Mr. Klug and says, no, it's an undue hardship. And so the importance for listeners is, if the subjective, emotional distress of a student saying, I felt uncomfortable, I felt emotional distress, is enough to get a Christian fired, but when they're saying here's a strongly held religious belief, that is a dangerous and scary standard for Christians in all walks of life. And so that's really what's at stake here. If a student can simply say, oh, this subjectively caused me emotional distress, that can't be the standard. And one of the helpful things that the Seventh Circuit said in its decision is that, in fact, there has to be some objective showing of emotional distress. And so that's one of the questions that's going to go back to the jury here. But listeners, just please understand, anyone could say anything. If you cannot in good conscience use someone's pronoun in the workplace, you too could face this type of religious accommodation request and potential termination of your job.
So this is why we're talking now, Josh. We need to bring this crazy out because our audience needs to have the equipping. We are growing, Josh, this Indiana Family Institute, where Josh works as the Church Ambassador Network, is growing like a weed. And it's a good weed, a reason why Indiana is protecting family values. Republicans and Democrats together, coming together. It's not a partisan issue to protect kids from pornography and other things. These are wild, weird activists that need to be called out where they live. And that's why this case is so important and why we're highlighting it. But one of the things, Josh, that I want our listeners that are listening to this logic, and this is why it's so important, we have President Trump in the control now and the court system, is that what they're trying to do is establish, is my opinion, a religion, and that's the one thing our Constitution, our founders said not to do, right? What they're trying to do is to say we're intolerant of one religion, Christianity. And so therefore we've established our religion in the school district to exclude some American citizens' thoughts from being, available to them. The thought police and the rest of the stuff, I don't see it as anything different than that. because I come from school districts where there's 47 different languages spoken in several religions. I think it's bigotry, and I think it's intolerance, Josh. When people try to impose a policy like this on a pluralistic makeup of a public school district, is that a wild statement from me, or do you think we're starting to discover that what I'm saying is factually true, that it's actually intolerance and bigotry that we're fighting, not what they're trying to say it is?
So I think you're absolutely correct, Craig. And the sexual revolution is, I look at the case, I think what this is really all about is the sexual revolution has moved from an acceptance phase, like, oh, we just want to be accepted, we want to be included, to an enforcement phase, meaning you will celebrate with us, you will come along with us on this. And if you don't, you'll lose your job. And we previously talked about a family that we helped here that lost custody of their child. I mean, this is what's happening. This is the development. And it is curious to me, just from a human perspective of just interacting with others, trying to be respectful. Why does an individual basically saying, to be whole, to feel myself, I have to force you to violate your deeply held beliefs? And Klug has put in the record that he believes to refer to a student contrary to their biological sex is sinful because it's false, it's untrue. And scripture clearly says not to bear false witness. So basically, I have to force you to sin against your conscience for me to be whole and not to feel emotional distress. I think that's where we are. One last piece of evidence here, and this is what we filed our amicus brief on, is the school argued and the district court agreed that the Indiana Constitution requires that schools be open for all. So there's a requirement there, and use that to say, well, all students have to be treated equally. There has to be open access. And therefore, the 1851 Indiana Constitution, I've written in 1851, folks, supported the fact that Klug had to lose his job because he would only use last names. That's where we are. And so I think you're exactly right. The just presumption that non-affirmation equals some sort of harm has been throughout this case. And we know from Scrimeti, I think Scrimeti is going to help with this, because Scrimeti says the state has a rational basis reason to prohibit hormones and surgeries. But Scrimeti did not go into some of these social transitioning pieces with the pronoun uses. And so that's, I think, the new front line. And so Klug didn't know it in 2017, that he'd be here in 2025. But that's exactly, I believe, where we are. Just that presumption throughout the case proves, I think, your point, Craig.
So, folks, we're going to have fun with this. It's an opportunity for us to introduce people to the truth, right? Because the reconciliation of this will not occur. It will not make sense to people. It cannot make sense. It's all been built on lies. The sexual revolution over 70 years, and it's coming apart. And as the good book says, you'll know it by its fruit. So we're at the front lines, and we talk about these ridiculous cases, and this poor John Kluge, who's still trying to make his case in Indiana, and why it's so important that FPCs. This is why you support FPCs. This is why I'm a national organization. I tell you to support your state organization first, right? Because they are the front lines, folks. They're the ones that actually represent this teacher and can take this. So people say, Josh, all the time, I wish there was somebody, and they haven't heard of us yet. Well, guess what? We're the ones. Just like the left, we have hundreds of organizations that were at the Social Conservative Conference a couple of weeks ago in Indiana. We work with the Alliance Defending Freedom that is leading on this case. Some of the best lawyers in America doing what the ACLU should have been doing if they lived up to their own charter, standing up for our civil rights of Christians and American citizens. If you want to hear, this is my commentary, Josh, when what you just said on the left, when they talk about democracy and all the rest of it, it's projection. This is why you need to be concerned. Why have they been talking about ending democracy for the last 8 years? The reason why is they are in a minority, and they know that. And when Christians start voting again, we're going to start winning 49 states. That's what we fought the wars for. That's what we created America for, was for our religious liberty. And that's what should be taught in our schools, Josh. Sorry for the pontification, but that's why you're on the show today. How can, and what should the audience be saying today when they're hearing and they know and they say, I'm going to help Indiana Family Institute where you live and say that first, but then transition to there's somebody just like us in your state and how they should approach those people, whether it's the church ambassador people or the FPC.
So something that I have just been blessed by, certainly SoCon, a social conservative conference put on by FPA, just to put a plug in, it was such an encouragement to me to be there with like-minded folks from around the country, being able to hear of stories of successes, real challenges, the real challenge that kind of our brother in arms, Jason McGuire, is facing there in New York as he was politically targeted and is even spending weekends in jail. I mean, it doesn't get more serious than this. But when I think of the groups that are doing the strategic, hard work to make a difference in the United States to promote created order, religious liberty, human flourishing, the groups around the country affiliated with FPA. So, if you are in one of the 40 states like Indiana, where I am, we have an office near Indianapolis. We stand ready to assist those in the Hoosier state with these sorts of things. But then if you're in another state and something like this comes up, it's time to pick up the phone and contact these groups. Craig, I did want to drill down maybe just one more level into this is not hypothetical. All right. This could impact you. I'm sure there's listeners that may have had those conversations. You got to put your pronouns in your email. You've got to refer to a coworker using preferred pronouns. So I can't go into as much detail as the Kluge case because this case is initial. It's an ongoing litigation. But let me read to you from, this is a matter right here in Indiana. So let me read just a bit here, and I think you'll catch on exactly what's going on here. So Stephen Ressler is a devout Christian who believes there are only two genders. Ressler began working for IKEA in 2019. Consistent with his beliefs, he treated his coworkers with respect by using their first names, but he could not in good conscience use they, them pronouns. On December 9th of 2024, he was suspended by IKEA pending an investigation for allegedly misgendering a coworker. On December 27th, he submitted a religious accommodation request. On December 30th, Ressler was terminated from his position due to the alleged misgendering. So this is not hypothetical. This is, I think, again, one of the front lines of what we're going to continue to see unless the Supreme Court weighs in on some of these issues.
Let me give a couple of straw men too, because part of what we do, Josh is a trained lawyer, so he's not going to play all these games with me because he's an officer of the court. So if I go to an AA meeting, I say, hi, I'm Craig and I'm an alcoholic. And everybody knows that, right? But most Christians and most psychologists would say, that's a horrible thing to say because you're a person, right? You're not an alcoholic. You're a person that had an addiction problem, right? Like be easier on yourself. But it's a way of us ripping the Band-Aid off and saying, I'm over it. You know what I mean? I have an affliction that leads me away from where I should be. I'm an alcoholic. Now, if I said to other people that it would be better now that I've discovered sobriety, I've got 15 years, it would have been so much easier if every time I went into a bar, everybody else said whether or not they were an alcoholic. Whenever I go into a workplace or a restaurant, I'd like to know if you're an alcoholic. That's what people are doing, just remarkably selfish, and it's ridiculous at the same time. And most of the accommodation was, wow, this poor person really needs this. But then the other side of it was, okay, it's not being used for that. It's being used for self-centered stuff. It's being used to be intolerant of my beliefs, is what I'm saying, on the rest of it. And worse, this is what I want to say. The worst part about this is when you live in a society where people say, I'm a black person, I'm a gay person, I'm an alcoholic, I'm a CEO and everything else, you have no culture at all because that's the height of DEI, right? And that's as Christians what we're actually against, Josh. So I just wanted to say, this is ridiculous on so many levels. It's the height of idol worship, of self-centeredness, but too liberal, things too. I don't even know any liberals that would say in that you can be reduced to your identity. Like if I said you're just a this race, left-handed person from that state, they would be mortified by that. But that's what they're trying to get us to announce when we go in a room. So I just wanted to walk through that cycle with you of the hypocrisy and the ridiculous nature of it as you go into a jury trial. Do you believe that Americans and that would show up in juries will start seeing that loop that I just gave? We're like, well, how could your regime of pronouns actually make any sense if we're talking about every other interaction in all those rooms? It's so unique, or is it so unique when it's sex we have to have a different set of laws still?
So an Alliance Defending Freedom that will be, taking point on that, their public statements are certainly affirm that they're confident as they head into a jury of peers that this was a completely reasonable request. It didn't unduly burden the school, and that they'll side with Mr. Klug. And even to think of kind of where we were in 2020, 2021, to see where we are today, and even the cultural shifts, that kind of uncommon return of common sense. That's certainly the prayer that people will catch up. But Craig, you hit on something that I've scratched my head on with this case, with Mr. Ressler's case, is how did we teach the next generation that disagreement equals disrespect? Because that's what's going on here.
Right.
It's like, oh, I disagree with you. Oh, you hate me. You disrespect me, to my very core. That it's a dignitary harm. Where did we get there? That's contra to the First Amendment. And so I think there's certainly the legal side of this, but then even for listeners, just in their own families and their own spheres of influence, pushing back on that and saying, no, disagreement is not disrespect. I can love you, and I do love you. I just don't agree with your choices. So we've got to recover that, I think, for our democracy to flourish as we move forward.
Well, thank you for that, Josh. Thank you for being with us. I want to remind our audience here today that we're trying to do something big together, and it's important. 40% of Christians do not participate in elections. 40% of the people that own the country, the state, the school district, and the city where they live entirely, where you are Caesar, you do not participate. And many people listening say, that's not me, Craig. I vote every 4 years in a presidential election, but we disregard the 2 or 3 other special elections, city council, other things where all of the money and influence on our kids actually is. So we need you to pause and participate, because it's issues like this that can unlock really good fruit. Like if more Christians participate, it wouldn't just be the school district. It might be your governor. It might be your state legislature that changes to being more tolerant, and less judgmental, and allow our children to develop in a way that frees them to flourish rather than a lifetime of chronic disease if they opt in for these surgeries, or slavery if they adopt these idols of their own. We want to encourage you. This is a time for you to be involved and to participate. It is hard for you to find those words sometimes, and that's why we want you to listen and share these podcasts with your friends. We try to help you bring common sense back, as Josh was just talking about here, and it comes from participating in groups like the Indiana Family Institute. Josh, please tell us, are you, as we go into 26, with so many victories that we've had, defunding Planned Parenthood, so many of these legal victories taking home at the local stage, sometimes you see where people lean into something, and sometimes you see where what was going on, where people are recoiling. In Indiana, are you seeing people leaning into these Christian social conservative victories, or do you think we're going to get a backlash next year because of them?
Thus far, I can tell you, I've really been blessed to see even members of the legislature that haven't interacted with us before. I think, after some of these long-term efforts, say to protect parental rights, folks that didn't interact with us before, seeing that as, no, that's an objectively reasonable, necessary thing. Oh, the right of parents to raise their kids should be fundamental. How novel, And so sometimes I feel like we keep restating very simple, basic stuff, but here we are. And thus far, especially from 2025, which was our most successful legislative session to date on so many of these issues that FPA is promoting, we're seeing, I think, even more of a groundswell of folks that want to join in the effort, at times even unlikely allies that in the past we would not have seen in.
Didn't you just pick up someone from Indiana who lives in Traverse City, Michigan in the last couple of weeks? I think that Mayor Pete, formerly of South Bend, Indiana, is using IFI and FPA's talking points now on protecting girls' sports. And so, folks, if you're auditing this podcast, please add him to those lists that the Indiana Family Institute and FPA are on, because he's now using our That's what I'm saying. This is getting funds because we're kind of winning on these issues. Doesn't it seem like, Josh?
It does. And you've mentioned Title IX. That is actually something to watch in Mr. Klug's case as well. And again, hopefully this continues in a winning streak. And the school argued, well, if we would have granted Mr. Klug's accommodation request, we would have faced liability based on Title IX. So the cases involving girls' sports that are heading to the Supreme Court now are going to be really important in addressing that. But we do sense that we even had an issue here recently where two young women asked not to be roomed with a biological male. And in the past, that may have had to have been fought, more intensely. But the school went ahead and granted that request. And they said, look, we don't want to be roomed with a biological male. And that was granted. And so I do sense that it's a great day. It's a great opportunity. And we're thinking a lot about how do we steward this momentum well.
Well, with that, from your lips to God's ears, hopefully we can steward it well as you're listening to this, that you'll post this, you'll share it with your friends. You have discovered a resource that will help you get involved in honoring the Lord and advancing liberty, equality, and justice in America rather than these crazy DEI overlays that are robbing our citizens of their constitutional rights. Josh, it's been a privilege to be with you today from Indiana Family Institute, and we'll have you back on again soon. And for all the rest of the guests, until next week, be blessed.